Okay, I think we can get started. Welcome, everyone. Thank you for joining us in this webinar on long-term reform of First Nations Child and Family Services. My name is Tracy Lavin, and I'm calling in today from Squamish, Musqueam, Tsleil-Waututh territories, where it is beautiful and sunny. Before we start today, I'm going to hand it over to Judy, who can open us up in a good way. Judy, if you want to introduce yourself and then do an opening for us.
Thank you, Tracy, and thanks for everyone joining the circle today from across our country. And my name is Judy Wilson. I'm Our Children Our Way advisor, knowledge holder, and I'm going to open up with a few words of prayer, just a lot of reminders of what our elders share with us. So our elders, when we're growing up, they always stress to be aware of your surroundings, aware of yourself, aware of your own breath. So when you inhale and exhale, that's the sacred space between our universe, our heaven, and Mother Earth. So the heavens are like our spirituality, and the Mother Earth is like physical. So when you breathe, that space in there. So maybe for the prayer, just be a little conscious of the breathing as you're going. Cúxwumixw, Kilcookbe, Creator, we thank you, Creator, for this beautiful Mother Earth, and we pray that we can treat Mother Earth well, and also that everything that lives upon it, and also that we remain close to you, Creator, in all that you do and all that we do. And we pray that we can show great respect for all beings, that we can work together to benefit everyone upon Mother Earth, and that we can support and give assistance and kindness today wherever it's needed. And also that we do the right thing and the best that we can. And also that we can take care of our well being of our mind, body, and our spirit so that we can help others. And we also pray that we can share, Creator, your efforts for the greater good of all, and also that we can be truthful and honest at all times, especially truthful and honest with ourselves, and that we take full responsibility for all of our actions. And Creator, thank you for the elders and ancestors that reminded us those teachings, that we're energy and we're just one of many in Mother Earth and in the universe, and that we have that precious energy to share and treat others better, especially our children, Creator. This circle today is about our children and long-term reform. We pray we put our best thoughts together and our collective wisdom, that we can come up with those solutions that we need to. Please help the ones with love, support, and resources, mental health and addictions, and the elderly and the infirmed, and also the ones that lost loved ones this past year. So we pray for all of this, Creator. Please keep our home fires lit well, and also safe travels to all those traveling to the AFN-SCA this coming week. Cúxwumixw, 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 Cúxwumixw. Thank you, Tracy.
Thank you, Judy. All right, so just a quick overview of our agenda for today. We'll do a round of introductions, and then we have some information from the National Children's Chiefs Commission on centering rights holders in the long-term reform of First Nations Child and Family Services in Jordan's Principle. Some information from the Caring Society on the litigation and evidence to end Canada's discrimination, and a presentation from the Expert Advisory Committee on reforming Indigenous Services Canada as a department. We may have a short amount of time for questions. If we do have some time for that, you're welcome to put your questions in the chat, and then Judy will close for us at the end of our hour. So I'm going to hand it over now to the panelists to introduce themselves. Richard, do you want to start?
Yeah, thank you, Tracy. Wali giskeg said when Ninawe Delawizin Richard Gray listed Gujilnu said Nogama. So my name is Richard Gray. I'm the manager of social services for the First Nations of Quebec and Labrador Health and Social Services Commission. All my relations, brothers and sisters.
Thanks, Richard. Cindy?
Good morning, everyone. I'm joining you from Sḳwx, and my name is Cindy Blackstock. I'm the Executive Director of the First Nations Child and Family Caring Society, and we are one of the co-complainants in this human rights case.
And Amber.
Hi, my name is Amber Johnson. I am representing the Expert Advisory Committee today. I am a historian and I run a historical research firm known as Birchwood Historical Research. And I'm just very happy to be here, and thank you so much, Judy, for the wonderful opening.
Thanks, everyone. Before I go into Richard's presentation, I just want to, for those who are joining us in French, we don't have the slides in French today, but they will be available on Monday. If you're looking for a French version of these slides, you can let us know. And a similar version of this presentation will also be provided at the dialogue session at the Special Chiefs Assembly on December 1st, which is Monday. So Richard, I'm going to hand it over to you.
Yes, thank you, Tracy. So regarding background, there's been years of trying to work with Canada to address clear inequities in services for First Nations children and families. And this all started in 2007 when the Caring Society and AFN filed a human rights complaint against Canada. And after nearly a decade, the CHRT substantiated the complaint in 2016. It's notably known as the merits decision. And since then, there's been more than 20 additional orders to force Canada to end its discrimination, to reform the Child and Family Services program, and fully implement Jordan's principle. In July of last year, Canada, AFN, and interested parties from Ontario drafted a final agreement intended to fully address Canada's discrimination in the First Nations Child and Family Services. It had a number of shortcomings, and the Chiefs did not believe this agreement would end the discrimination. So in October 2024, the Chiefs rejected the agreement and created the National Children's Chiefs Commission to guide a new process. So the next slide, a little bit of the NCC and who we are. We've presented in the past, so this is just a reminder. So the National Children's Chiefs Commission has a mandate to provide strategic direction and oversight of long-term reform for First Nations CFS and Jordan's Principle, and has representation from 11 regions, excluding Ontario, where chiefs are pursuing their own process. The NCC has appointed a chair, Chief Pauline Frost, and a co-chair, Deb Foxcroft. They have assembled as well a legal team, a negotiating team, a technical team, and secretary support, all without any funding from Canada. Next slide, please. So regarding NCC efforts to re-engage, the Commission has a mandate to negotiate and has focused on persuading Canada to resume negotiations. As you can see in the slide, there were a number of letters that have been written to Canada to try to engage in negotiations. So we've repeatedly reached out to Canada over the last year, and Canada's response has been silence, questioning the role of the mandate of the Commission, and has indicated that they've had superficial meetings we describe later as consultations. The Prime Minister and ISK Minister have both made public statements about the importance of getting back to table, but they've not knocked on our doors to say, we want to talk with you. And the reality is they have strongly and persistently refused to do so despite all the letters we've sent to them. In fact, they have informed the tribunal that no further consultations and negotiations are required at this time. Next slide. So regarding the latest CHRT or one of the latest CHRT orders, 2025 CHRT 80, we call it. In August of this year, the tribunal called for an end to Canada's delay tactics. One thing Canada cannot do is simply wait and let time go by anymore. And the focus, once again, has to be put back on the children and their long wait for justice. CHRT 80 clarified that the order must cease discrimination. The order to cease discrimination is permanent, that reforms must protect children for generations to come. The Ontario and national processes will proceed in parallel at the same time, and that all First Nations viewpoints are valuable. They reminded all parties as well of the clear parameters for long-term reform remedies. Next slide. So a bit more information about CHRT 80 orders. Regarding the CHRT 80 order, they gave the parties 4 months to come back with a national plan, long-term reform plan. This plan does not include Ontario. They offered the parties to work together or submit separate plans, and Canada chose to submit its own plan, which is very unfortunate. The tribunal will choose from the submitted plans, and we have until December 22nd to submit our own. Regarding the CHRT 80 parameters, the tribunal also outlines some parameters on long-term reform based on orders over the last 9 years. So the plan has to consider funding that meets needs now and for multiple generations. It must be flexible and promote evidence-based measures that improve on previous orders and respect the spirit of those orders. It must be guided by excellence rather than perfection without compromising on children's rights. It must incorporate and respect distinct needs, circumstances, and perspectives. It must be culturally appropriate and reflect culturally based interests of the child. And finally, comply with domestic and international human rights. Next slide. So regarding the engagement themes, the Caring Society and the NCC collaborated to develop these engagement themes, questions, and tools in preparing for our national plan. We wanted to look at purposes, principles, and definitions because these are important tools for interpreting the national plan. Regarding governance, and we wanted to look at who will guide and oversee the implementation of the national plan. Regarding enforcement and durability, we wanted to look at how the plan will be enforced, when, not if Canada fails to comply. Regarding the funding commitments, this is the crux of Canada's discrimination and how First Nations Child and Family Services will be funded. Concerning accountability, we wanted to look at how to hold Canada accountable and how to be accountable for public dollars. Regarding regional variations, which is very important, we wanted to have discussions on how to accommodate the distinct needs across the country. And regarding reform of Indigenous Services Canada, we wanted to look at how to reform the department so that discrimination never happens again. And concerning research and outcome data, we want to look at how to monitor the outcomes of reform to find out what is working and what needs to be adjusted. And finally, we want to look at transition and readiness and how to ensure children do not fall through the cracks during the process of reform. Next slide. So regarding the regional engagements, each region took charge of their own engagements, and they were supported by existing organizations. And I want to take my hat off to all the regions and those organizations that supported this regional engagement process. Many responses were received, and now we are using a qualitative analysis supported by Julie Havelston at University of Toronto to help us in the analysis of the information we received. Next slide. So I'll get into a little bit about what we heard on those engagements, specifically on the definitions and principles. These are very preliminary findings. So we heard several terms and principles need clear, plain language definitions grounded in First Nations perspectives. We heard inherently colonial and discriminatory features of concept like on and off reserve, noted by many respondents. We heard that reform must support holistic and interconnected features of well-being. For example, child safety depends on connections to family, culture, community, the land. And we've received as well some interesting quotes as well. Some have stated, one stated that as communal people, the well-being of our children is the outcome of the well-being of our communities. Children are the reflection of the wellness of the society. And another quote stated that we must have the resources needed to connect our children in care with the communities, culture, language, and history. Indigenous children are nested and protected within their lands, nations, communities, and families. Our children and families are the cornerstone of our future. And finally, we heard that principles and definitions must be grounded in that perspective and are critical for reform efforts and for staying accountable to First Nations. Next slide. What we heard on governance. We heard strong views that First Nations right holders must be central to governance. They must hold decision-making authority. They must guide all structures, priorities, and decisions related to reform. And that reform must focus on community-level input and Indigenous law. We heard that chiefs can speak on behalf of rights holders. We heard that experts can provide information and guidance, but decision-making ultimately rests with rights holders. Next slide. So governance continued. We heard that the Caring Society and the National Children's Chiefs Commission are supported as crucial participants in governments, but not as decision makers. The NCC can ensure fairness and justice for all children and uphold the spirit of the tribunal rulings by overseeing the implementation of agreements, monitoring Canada's progress, ensuring funding aligns with community needs, and report on outcomes. We heard the NCC was valued for its neutrality, regional representation, dedication to the best interests of children, and the vital link between national reform and community realities. We also heard the Caring Society's role focused on ethical oversight, research, policy, and advocacy, and that the Caring Society was valued for independence, credibility, their track record for defending First Nations children, upholding spirit and intent of tribunal orders, and is seen as a watchdog and rights-based advocate. We heard significant opposition to the AFN playing a role in the rollout of funding or decision-making, but we also heard that AFN can play an important role in political advocacy, national coordination, information sharing, be supportive, not supervisory, and that any involvement must be transparent and community-directed. Next slide. Finally, on governance, we heard that First Nations chiefs are essential to governance. They represent the political voice of their communities. They define community needs. They set strategic priorities. They approve mandates. They hold Canada accountable. We heard about the importance to clarify boundaries between political leadership and operational services management. We also heard that regional First Nations leaders should play an important coordinating role in advocacy, coordination, oversight of regional and national appointments, highlight distinct regional needs, elevate issues to national tables. We heard regarding youth, them being critical expertise based on lived experiences of First Nation Child and Family Services. We heard the work should be guided as well by the wisdom and knowledge carried by elders. So the analysis continues and is ongoing, and there's more to come. So that's it for me, my brothers and sisters. Now I pass to Cindy for more details on the Caring Society's work. Thank you very much. Miigwech.
Well, thank you very much, Richard. And I would just note that much of the feedback that we received so far aligns with the comments made by Chiefs in Assembly in Calgary, the idea that there should be First Nations transparent oversight, and that inspired the creation of the National Children's Chiefs Commission, is certainly something that the Caring Society fully supports. And we look forward to further collaboration around governance mechanisms that keep something like that in place. So I just wanted to recognize them and recognize all the First Nations experts across this country who have done incredible work. First of all, supporting children, youth, and families, and second of all, supporting their leadership in this important decision making. Richard has covered a lot of information. I'm just going to pick up some additional pieces as we go through. So next slide, please. So on this CHRT 80, one additional piece that I want to note is that the parties were ordered to file monthly updates with the tribunal. The Caring Society has collaborated with the National Children's Chiefs Commission to file monthly updates at every turn. You can find all the monthly updates at fnwitness.ca. And you'll see one of the important pieces that we were paying attention to from the feedback in Calgary was the inclusion of First Nations who are not members of AFN, which are many of the First Nations leadership in Alberta. And I just want to recognize the leadership and the technicians in Alberta, and it's been a real pleasure to collaborate with them to make sure that their views are also heard in this process. Another important learning from the final settlement agreement is many of you who are who, in addition to speaking your own First Nations language, prefer to speak French or do speak French. And it was only released in English. And we were able, despite any funding, to make sure everything was translated. And we did get French submissions, and we're so grateful to those communities and to have their voices heard in this. Canada has also been required to file these monthly updates, but they've been, I think, vague and anemic would be the two words I'd use to describe them. And indeed, I want to just read you the one that came in this morning from the Government of Canada. It says, this letter provides the Attorney General of Canada's monthly update for November 2025, as ordered in 2025 CHRT 80. Discussions are continuing within the Government of Canada on the highly complex, polycentric decision-making required pursuant to 2025 CHRT 80. There is therefore nothing new to report to the tribunal at this time. That is the level of attention that Canada is giving to this particular file. And no one disputes the importance of consultation. We've seen the minister talk about it at length. But as Richard's report makes clear, and the Caring Society's reports to the tribunal make clear, is they are not talking to us. And we see no consultation happening or reporting happening on their end. Next slide. So these minimum standards, one of the big pieces I'll be looking for in Canada's plan is the evidence. They have over 25 years had evidence-informed solutions available that were developed with First Nations, and they simply piecemealed them or ignored them altogether. I'm hoping that they're going to break that pattern when they file their submission on the 22nd of December. However, I suspect they won't. And in fact, I'm a bit concerned that we'll see something equally as anemic and vague as we've seen in these monthly reports. Next slide. So a couple of things that I just want to remind everyone is that there are parameters around this engagement. First of all, it had to deal with matters within the tribunal's jurisdiction. It will engage Jordan's principle to the extent it's linked to child and family. And we're already seeing, it's interesting, the federal government says well, we've only cut Indigenous services by 2%, but many of you on this call know that they began heavily restricting and indeed, in my view, cutting Jordan's Principle and Child and Family Services in advance of these cuts. So I think it's important that we look at, compared to last fiscal year, what is their funding overall? And I think those cuts are unfortunately going to exceed 2% and needs to be safeguarded against. These are minimum legal standards that need to be in place. Canada has repeatedly wanted to have maximum decision-making, maximum discretion, and has proven when they have that and it's not constrained, that discrimination results. Next slide. So those are the engagement themes. I won't go over them again. Next slide, please. I do want to point out that Canada continues to fight First Nations children in court, both in Jordan's Principle, with the Powell's case, which is a very honorable elder and grandmother looking after her 2 grandchildren in the Federal Court of Appeal under Jordan's Principle. And as well, they're fighting this decision. I can't figure out what they're fighting because they're basically ordered to go out and create a plan to stop their own discrimination. Is that what they don't want to do? Or they're also ordered in this to not apply the Ontario Final Settlement Agreement to everybody else. They've written to the tribunal to say that's exactly what they intend to do. They intend to use it to inform national reform. So is that why they're appealing this order? We don't know, because the statements for which they filed for judicial review are very vague. The current status of this is that the case management judge has been appointed. It's the Associate Judge Mulgat. In Canada, with support of the Chiefs of Ontario and Anishinaabe Nation, prefer to have the matter heard in writing, but the Caring Society and the Assembly of First Nations object to it being in writing. It is of vital importance, and there are specific oral arguments that we want to make. So that's where the matter on the judicial repeal happens, but it's important for everyone to know that they are actively fighting. Next slide. Richard went through this eloquently, so I won't, other than to say that we're also building on the research, which is the next slide. Sorry, Tracy. The next slide that is already on the books. The one great thing in Child and Family Services is we have had experts, and I just want to acknowledge the experts and leaders and elders who have been such an important guide of this work over 25 years of reports and recommendations that are evidence-informed to remedy Canada's discrimination. Included in these solutions, this last round, we have the Institute of Fiscal Studies and Democracy, that's IFSD, and we have had reports done with them that are what they would call bottom-up, which means working right with First Nations and First Nations agencies across the country to come up with these publicly costed solutions, which Canada has not implemented. They say, for example, things like, well, we're rolling out the 2,500 for prevention, but that 2,500 assumed you had staff, it assumed you had buildings, programs, all this infrastructure. And what they did is they split it off, and they didn't always provide First Nations who needed it the capacity to deliver it. So there's real departures from this research that we're already seeing in Canada's approach. You can go and look at all of these various studies on these websites, and we'll certainly make these slides available to you. Next slide. So some key dates coming up. There's the monthly reports. Well, we've got another one coming up in December for Canada and for the Caring Society. And then we have to file our plan with remedies, which is going to be much better thanks to all of you who have, and I join Richard and the National Children's Chiefs Commission in recognizing the heroic efforts of people in the regions to provide us this much needed feedback to inform the plan. And then we file it, and the tribunal will determine next steps, but we'll also be able to suggest what we might recommend for some next steps in terms of resolving child and family services. So how you can help? First of all, if you have a chance to meet with the minister, Really, I'm really concerned to hear this. We're going to consult as a way of not acting on the chief's direction that's already on the books. So we need to make sure that they are not using that as a way to obfuscate their responsibilities, and that they actually are consulting on things that matter. Like, where the heck have they been on this thing? There's no consultation plan, no engagement plan, nothing from Canada on this, which is the same approach they've used on C5 and S2 as well. You could make a contribution to the National Children's Chiefs Commission to support their work. It's all volunteer. Some of you will know that I've donated one of the quotes I wrote at the tribunal, and I want to recognize that it raised $9,000. But that's a little bit of money. But all of you can do your part too. So if you can, just send the money to the National Children's Chiefs Commission and support their incredible work. And that's it for me, Tracy. Thank you very much, everyone.
Thank you, Cindy. We'll go on to Amber now.
Hi, thank you very much, Tracy. So I'm just going to give an update from the Expert Advisory Committee. You can change slides. So just to go through a few of the things I'm going to talk about as quickly as possible, who we are, what we've been up to, the challenges that we've encountered, some key recommendations from a progress report that we brought out in 2024, some recent developments, and how we want to move forward. So the Expert Advisory Committee was established to provide independent, informed guidance on eliminating discrimination, Indigenous child welfare, and bringing an evaluation to Indigenous Services Canada. We bring together experts, and we're I will say a great team, and we all work together quite well from a wide range of fields. So we have law, psychology, history, social work, Indigenous knowledge and culture, advocacy, health, addictions, and evaluation. And what our collective expertise does is it brings a well-grounded ability to bring recommendations that reflect both historical and contemporary realities. Our members include Alanis Obasawan, myself, Carol Hopkins, Cedar Iatail, Kevin Page, Larry Bremner, Naomi Metallic, Raven Sinclair, and Rod McCormick. So a summary of our activity from 2022 to 2024. During that time period, we were assisting and providing evidence and providing expertise on the creation of an evaluation monograph that would have supported the third-party evaluation of Indigenous services, developing our terms of reference, which still have not been solidified, looking at cultural competency training within Indigenous services. And when our suggestion was never to use the term cultural competency, but to change that system to reflect cultural humility training instead, and having caucus meetings. This was oftentimes a point of contention with Indigenous services, that the EIC was meeting outside of our meetings with ISK and the co-parties, but the EIC felt it was very important that we became a cohesive group. We're able to discuss how we would move forward, discuss our recommendations and things like that. So I think up to this date, we've had 26 or 27 caucus meetings. Challenges that we encountered in 2024 to 2025, work stopped. So work stopped, I think it was in May of 2024. We were sent a letter to cease and desist working on different files, and to wait, of course, for the FSA, which are terms of reference that were changed by ISK, were added to the FSA, which was, of course, turned down by the chiefs. We've had a lack of communication for over a year, no work completed, no work on the evaluation, no work on cultural humility training, nothing like that, no meetings. So, and no, of course, the EAC did not receive any payment either during that time period. No clarity on the EIC's ongoing role, no mechanisms in place to honor past commitments or agreed upon processes. And of course, most importantly, which has been a point of discussion, a limited ability for the EAC to operate as an independent body. Next slide. We have a report, and this can be provided to everyone. It's also available, I believe, on the Caring Society website. Our recommendations included addressing structural racism and redesigning discriminatory systems within Indigenous services, recognizing and addressing the impact of historical trauma and cultural dislocation, advancing community-led rights-based approaches to child welfare reform. We have a great model in place that is an EAC creation to develop critical incident reporting mechanism that would allow, if something happens, you'd be able to work faster than the past in getting in there and helping that child who needs help immediately. Offering expert advice on short, medium, and long-term reform to end systemic discrimination in Indigenous services. And most importantly, ensuring strong Indigenous oversight and meaningful inclusion of youth voices. We do have a youth member who we value greatly on the EAC. And the shift, of course, as I mentioned earlier, from cultural competency, which we don't believe is possible, to cultural humility training and practice. So we want ISK employees who are interacting with Indigenous or First Nations peoples to be able to handle the situation properly. We heard a lot of different stories about things that were said that were quite terrible. So that was something that the EAC found to be very important. Next slide. Recent developments, we have received new correspondence from Indigenous services indicating that we will be having our first meeting for over a year and a half on December 8th, 2025. And this is, we're tentative in our excitement over this. The EAC is ready to go. Everybody's going to be coming to in person to Ottawa to engage with Indigenous services and the co-parties. And we feel this is a concrete step towards re-engaging because it's going to take some time to find out what's happening, what Indigenous services has been doing in our absence, and to kind of rebuild that relationship with Indigenous services and the co-parties, and so we can get back to work. Moving forward, the EAC, and we have remained committed, and we have stayed committed throughout this time, and we have met regularly, even though we did not have any communication with Indigenous services, to have a working relationship. We intend to use this meeting as an opening to advance our work and our mandate. We will continue to prepare recommendations, strengthen our internal coordination, and uphold responsibility for ISK, as well for us to provide that expert independent advice in support of reform. So some of the points we want to advance, we want to get a terms of reference in place that is works for the EAC as well as for Indigenous services and the co-parties. And that clarifies our expectations regarding our mandate. Reaffirm the importance of communication and transparency. Ensure alignment with the goals established under the CHRT order. And very importantly, reinforce our full support for the efforts and direction of the National Children's Chief Commission as a key partner. And the EAC has always supported the Commission and tried to provide any assistance that or expert advice that we could to them. And we continue to work in partnership. I hope to work in partnership with them in the long term. And of course, renew our role in advancing the evaluation, advancing all those different parts of our mandate to bring Indigenous services up to par. Thank you. And I just want to thank everyone for having the EAC come today and give a little update. Thank you so much.
Thank you very much, Amber. So we do have a few minutes for questions and answers. I have one question in the Q&A. It says, thanks for the update, Cindy. I've dealt with Jordan's principal in Edmonton. Application for an EA has been in the system for 10 months. No response from ISC at all. Cindy, is this a question that you want to address?
Yes,
Good to see it.
thank you. And unfortunately, this is something we're hearing across the country, is that Canada is with impunity violating the time orders, as well as, in our view, their requirement to look at the substantive equality, the needs, the best interests, and the distinct circumstances of the children when determining Jordan's principal cases. There is an important legal case, the Paulus case. I briefly mentioned it. It's the one with the elder and grandmother. In this particular case, the two girls have severe asthma, and the home is infested with black mold. And I just pause here a moment to note that Canada is the landlord of these homes with such pervasive repair problems on reserve. So it has got its hand in both buckets, even though housing is outside of the general scope of the complaint, although I will say that it does play a role in the complaint because housing is a driver to child maltreatment and to creating needs on Jordan's principle. We see that the Indigenous Services Canada directly has a mandate to address the housing situation. So Canada on the housing side is saying, no, we're not fixing the mold. And under Jordan's principle, it's saying we're not fixing the mold. And that is currently before the Federal Court of Appeal. We're just awaiting for the decision on that. I am recommending very strongly that people actually consult their legal counsel and consider legal enforcement of the orders. We already have very strong legal orders for Canada regarding Jordan's principle. Those tools need to be picked up, and Canada needs to be held accountable for those standards. So we're doing our bit at the Caring Society, but we really recommend communities and nations do it. And we've done a webinar on this with some of the legal people to give you some general guidance as well as an information sheet. And I'll try and track that down and put it in a chat.
Thanks, Cindy. We have another question about definitions of on and off reserve. This is a question that came up in a chat, and it also is an issue that arose quite frequently in the regional engagements. So I'll read the question, and then Cindy and Richard, if you can weigh in. It says, I do want to ask about these colonial definitions of on-off reserve, status or eligible for status, ordinarily resident on reserve. This leads to concerns about the rights of First Nations people living off reserve temporarily or longer, and who are eligible for status but might not have it. This is resulting in concerns for their ability to access services and funding from First Nations Child and Family Services and Jordan's Principle. And this funding is now starting to be denied, at least here in Ontario. What are the perspectives of each of the parties on this call, and what is the best solution to ensure that all First Nations children are supported and that no one is further discriminated against or allowed to fall through the cracks? So I know this came up regularly in the regional engagements. It also came up a lot when the chiefs were considering the draft final agreement that was ultimately rejected, and it's just a key concern for many who are involved in this work. Richard, do you want to speak to it?
Yeah, that's a great question. And I know in our region, it's something that's very preoccupying as well for CFS agencies and communities. we know that uh, we know that communities have started receiving funds for First Nations representative services um, following the agreement in principle, and communities have been setting up those services, and those funds are based on total on-reserve population. So if you look at so that's a limitation, obviously. So if you look at C92 though in sections 12 and 13, uh, the act basically says that if service providers have children that come into their care, and we're talking about off-reserve members here, um, those service providers have an obligation to inform the community before taking any significant measure. And that's Section 12. And Section 13 says that those communities or IGBs can make representations. So if you can imagine the complication for communities and CFS agencies that have this limit on funding based on total population on reserve, and you know, with their budgeting for these funds, if they get numerous requests from other regions or cities in their region outside of their community, and they want to get involved, how are they supposed to provide proper representation for community interest to support those members, given the limitations in funding? So this is a real contradiction in terms of what the Act promotes, and yet Canada's actions in terms of providing limitation of funds to make those representations and support those families are huge contradictions and preoccupying for us. Um, we know that Canada as well, and Cindy could probably elaborate on this a little bit more. We know that in the CHRT proceedings, there was preoccupations mentioned by Canada in terms of bringing off-reserve funding as an issue to be addressed by the tribunal. So we're getting it through. We're getting these limitations in the program itself in terms of child and family services. And we're getting a limitation in terms of Canada saying, well, this is outside the scope and preview of tribunal proceedings as well in terms of addressing the discrimination complaint. But yet at the same time, we're told that First Nations, you have a responsibility via the Act, Section 12 and 13, under notice provisions to make representation. So I think there's a real continued discrimination in this regard that has to be addressed. Cindy, I'll pass it off to you.
Yes, thank you. And thank you everybody for your patience with my technology in terms of the links. I think I did a self-correction, and thank you, Lisa, for letting me know that I posted the wrong link. So there you go. Hopefully that one works on the Jordan's Principle side. Yeah, there's a couple of things that I think are important. Is the minister is saying she's out there listening to First Nations. If she is out there listening to First Nations, then she ought to have heard the continued statement that First Nations ought to be able to define who their citizens are, regardless of this colonial Indian Act. And certainly the minister and the prime minister have it at their discretion to simply pay for those services and figure it out with the provinces if they figure they owe them money. In fact, that's a definition that applies in Jordan's Principle. However, the federal government is unwilling to do that. The reality is at the Canadian Human Rights Tribunal is we are limited to the on-reserve federally funded pieces of this case. That is what we can do. However, I think it's vital that we undertake the work of looking at the overlay of with Jordan's Principle. We have seen cases in the past and happening right now where families are doing their very best to look after children who have specific needs. And when those specific needs are not met because of Canada's failure to comply with the legal orders on Jordan's Principle, that puts those children at risk for placement in child welfare care. This overlay has been recognized for over 25 years in written reports. And so we do need to pay attention to that. Jordan's Principle and Child and Family Services are related, absolutely. And we do not want to see families coming to the attention of child welfare where there are no child maltreatment concerns. And in fact, that is what is happening again because of Canada's conduct. So you'll see in the submissions, we have to keep them on reserve and in the Yukon for the Child and Family Services piece. But it is absolutely open to the federal government to do the right thing and recognize citizenship-based residency. They're just choosing not to do that. In fact, what we're getting a signal of, and I agree with Richard, is a very aggressive stance by the federal government where they indeed would fight anything that would require them to honor every First Nation citizen across this country.
Thanks, Cindy. We have another question for you. Any updates on Cully versus Canada? Did ISC appeal and did they finally approve the service?
Yes, I can tell you that ISC did not appeal Cully versus the Cully decision. I know that it was referred back. I don't know the status of the services at this point. But we can check with David Taylor, who's counsel for the Cully case. And can I just take this moment to say a huge thank you to Sarah Clark and David Taylor, who are our legal counsel and have, between the two of them, donated about 4,000 to 5,000 hours litigating for these on our case, in addition to taking on pro bono support for families. Like, I just think this is, I'm just beyond grateful. And they're not alone. The National Children's Chiefs Commission has legal counsel that has not been paid. Liam Smith and Scott Smith, they're not related. And their teams, which are just, really doing the important work without being paid. We hear about class action lawyers digging into the piggy bank of, demanding extraordinary amounts. But the flip side of that are people that are just doing the right thing for the right reasons. And I just want to really recognize them in this important work. So I will follow up with David and find out if little Charlotte got her supports. I will say to you that we made sure she got the help she needed while this litigation went on.
Thanks. We'll take one more question. And this is about eligibility for post-majority services. The question is about why youth that have been discharged or left care at 16 are not eligible for post-majority services.
Is that the age of majority in the province that we're talking about here? I know Ontario used to have this crazy thing where it was 16 and they considered children to be discharged from care. Do we know that?
I don't have that.
Okay, so maybe we could recommend to this person that they write back and just with a few more details, and then we'll try to get back to them with a more fulsome answer.
Okay, thanks. Maybe we'll take one more. It seems that Indigenous endeavors for partnership and recognition in such reports, such as RCAP and TRC, get smaller and less impactful, like two parallel lines in the horizon. We just become a little dot in the horizon. Does new and changing government, such as past and current Prime Minister, play a part in little to no communication at meetings for progressing our concerns? Can we expect leaps forward or still slow movement?
I'll just add my 2 cents in it. I just did a piece on policy options about this. I think that there needs to be a significant ventilation, cleaning up of Indigenous Services Canada and Department of Justice. We're seeing on, this is the top TRC call to action, child welfare. And Jordan's Principle is number 3. Like, these are the top ones to get right. They had every opportunity to get it right. And they still went back to their old behavior of piecemealing it, ignoring leadership, ignoring experts, and getting it wrong. So I think that it needs to be there. In terms of growing attention, I find the combined piece of having First Nations driven solutions so that we are evidence-based, we are working in ways that respect the differences amongst nations, and with this full participation, having that in place and being prepared to litigate, I think are really, really key. We cannot allow Canada to set the time frame, and that's what the tribunal is echoing. And I like that Richard pulled out that quote from their decision. Especially because our children only have one childhood, so I really feel that we need to push it to the front. And that's the only way that things get done. And that's why we're actually at a phase where we are seeing some relief on the discrimination, although Canada's doubling down later. It wasn't because Canada gave us things like capital funding or applying Jordan's principle to children recognized by their nations on and off reserve. We had to fight for those through non-compliance orders. And so I think until they clean house, we're going to continue to see that. I'll just use this moment to say one other resource the Caring Society is just about to press print on, and that is many of you have been seeing these air raids of ISK bulletins, policy bulletins in Child and Family and Jordan's Principle. I want to, and I think I'm going to be bold enough to speak on behalf of the NCCC and the Caring Society on this one. Neither of us were consulted on any of that. We found out of them in real time. And we've done an information sheet on those bulletins, on the ones that we're aware of, and we'll be releasing that today or on Monday at the latest in both official languages. So just to let you know about that.
Thanks, Cindy. And Tracy, I would just add supplemental information. We're very lucky and fortunate now that the AFN has assigned a new portfolio holder for this file, Child and Family Services and Jordan's Principle. We have with us now Regional Chief Francis Vero-Paul from the Quebec region, who's himself asked to take on this file to help support First Nations in terms of getting us to the table to move forward on settling this discrimination. And I can assure you he's engaged and committed to supporting NCC and Caring Society in addressing these matters with Canada. So we do have someone now from the AFN, but a committed regional chief who's there with us to support us in this file as well. So that's very good news moving forward.
All right, we're just about out of time. Thank you, everyone. Thanks, Richard, Dr. Blackstock, Dr. Johnson, for your time and your information today. We've had a number of questions about the slides and the recordings. All the registered participants will receive a copy of the slides and notification. We'll notify you when the recordings are available. We should have the recordings in both English and French, and we will also send out the French slides once they've been translated. And I'll just pass it over to Judy to close us in a good way.
I hope you can hear me. I'm actually on the road, going back from Victoria to Vancouver now. Sďwx, Creator, we thank you, Creator, for all of the blessings today and all the wonderful work that the National Children's Chiefs Commission is doing, and all the regional chiefs and the leadership across the country, and all of the technical support and legal support that are providing their time and dedication and commitment to bettering the lives of our children and preparing for the plan for the long-term reform. And we pray that our children will continue to be at the center of our heart, and also the focus the next week at the Assembly of First Nations, that we'll all work together with a collective mind and spirit to bring about these solutions, and all that the government will open their eyes, and also all of those working on this will come together in a good way. So we pray for safe travels for everyone, whether they're going home or joining us in Ottawa, or whether they're taking some valuable time off this weekend for rest, rejuvenation, and restoration. And please keep the ones that need that extra love and support and assistance in our minds and our hearts over the weekend. And also, Creator, please give them the comfort that they need and the help. We thank you for Mother Earth, the water, and all of creation, and we pray to keep walking in a good way, Creator. Cook's Jam, Cook's Jam, Cook's Jam, Cook's Jam. Thank you, everyone. Thank you, Tracy and Dr. Cindy and Richard.